You can still win your traffic ticket case by challenging the officer's testimony and what he claimed he observed. So let's say the cop does show up to court. Now you're there. Jury selection begins. The officer is now called by the state to get up there and testify about what happened. Now it's important to know, where was the officer located when he claimed you committed this so-called traffic violation? And what was his perspective on what he actually saw? And remember, one of the best ways to challenge the officer is if he didn't write down any notes. He can many times say, I don't remember, I don't recall, it's been so long ago, I don't remember, I have thousands of traffic stops that I do. Remember, you don't have the burden to prove anything. The state has the burden to prove even a traffic violation beyond a reasonable doubt. Okay, it's really important to understand that if they're trying to make you pay a citation here, the more the officer doesn't remember, the more unreliable his testimony is. For example, let's say an officer did not have a clear line of sight or was not fully paying attention. I see this happen a lot when an officer drives by someone in a split second. Let's say you're driving this direction and the officer's driving head on in your direction and you just passed. In a split second, the officer didn't really observe much, and you can introduce doubt about what all these conclusions he came to just by driving by you. If you were driving 60 and he was driving 60, there's no way he caught much of anything going on because of the speed and the instant moment of what he saw.